Hi, welcome back to my channel Survidaya 77. Friends, today we will discuss about the legal and court reporting. This first part of the video will emphasize on understanding the judicial system, while the second part of the video will focus on how to become a good reporter and also focus on the legal terminology. The basic function of any democracy is its rule of law.
And judiciary is one of the important pillars of democracy.
Therefore, the coverage of courts fulfill part of the watchdog function of the media. There is a great deal of public interest in what the courts do, particularly in the criminal cases. In fact, I was reading a news report by Shruti Sagar today in Scroll that how two legal websites have transformed the way India is reading about courts and understanding the law. One of them is livelaw.com and the second one is Bar and Bench. These two websites have revolutionized legal reporting by tweeting about the proceedings in the real time, bringing them to the screens of general readers like you and me. Even though television cameras are banned inside the courts, these publications offer updates in the near real time with their live tweeting about the proceedings. And the speed at which they upload not just the court orders and the judgments, but also the petitions and pleadings of a case are incredible. So these resources were, available until recently only to the lawyers of a particular matter. Friends, over 4 crore cases are pending disposal in various courts in India. And this shows that access to justice for all has actually become a reality. So reporting of the judicial decisions from the lower courts to the Supreme Court has made people aware of their rights and has ensured a sort of, access to justice for all. So court or a legal reporter is somebody who reports after attending proceedings, of a particular case in the court. So I feel that transparency is, intrinsic to democracy, and the legal beat serves the critical role of being the bridge between a common man and, the highest pedestals of justice to which the nation looks up to. Of course, a degree is desirable in law for journalists to pursue the legal reporting, particularly for High Court or Supreme Court. But in our country, very few law graduates take up journalism as a career. But I remember last year, there were 3 lawyers in my class in English journalism at IIMC. So it is important for the budding reporters to acquire at least basic legal knowledge on jurisdiction of each court, its procedures, its hierarchy, to take up the legal reporting. While the reporting on the court proceedings and the judiciary, it is paramount that we maintain the sanctity of the institution, the legal institution, the judiciary. So in court and legal reporting, there is no scope for committing any error. Any minor mistake can result in contempt of court, or land you in trouble, or land your organization in trouble, or a defamation suit, or a contempt of court case. So it is therefore very, very important to understand how much of the tightrope walking it is for a journalist who takes up the legal beat. So the legal reporters, they face a lot of challenges. I have a lot of legal reporter friends who tell me that if you bypass a legal terminology, or the dissemination of news in a language that commoners do not understand, that is also a problem. To respect the institution and yet be critical is also very difficult. to stay clear of, being in contempt of court is also very, very difficult, among all the other challenges that they face as a journalist, in their daily lives. Today, we will first discuss about the historical background of the judiciary as well as the legal reporting in India, very briefly. Then we'll discuss about different layers of judicial, hierarchy, and also talk about the role of a union law ministry, the appointment of judges, and so on. So let us start with the historical background first. So Indian judicial history actually dates back to the Vedic age, where the law evolved. Today has religious prescriptions also, which are based on Upanishads or Vedas or customs or other texts. These have been incorporated in various laws passed in India. The method of law reporting to preserve the judicial decision and the principle of authority of precedent have been also adopted in our country from England. As in England, a court in this country is bound by the ratio decidendi of every case decided by a higher court. But the Supreme Court and the High Courts are not bound by their own decisions. I remember a case in Bengal Immunity Company Limited versus the state of Bihar. The Supreme Court held that it can depart from its previous decision if it is, convinced of its own error and its baneful effect on the general interest of the public. So the same is the position with the High Court also. If you talk about the history of law reporting in India, it can be divided into two parts. The first dealing with the early stages of its development, roughly a period, say, between 1813 to 1861. After the First War of Independence, 3 high courts were established. The first being the Kolkata, that was Calcutta first, now Kolkata. Then Bombay, now Mumbai, and Madras, now Chennai. They were established in 1861. So the second, with a more regular course, which is said to have commenced with the establishment of Presidency High Courts in 1862. Hitherto, law reporting was not regular. It was not systematic. It was only with the establishment of the high courts in the presidency towns in 1862 that the regular law reporting commenced. From that time, semi-official and the private law reports, they came to be published regularly and also systematically. I read somewhere that Sir James Stephen, who was the law member in the Governor's General Council, he recorded a minute to the effect that law reporting should be regarded as a branch of legislation. He also accepted the principle that it will hardly, it was hardly a less important duty of the government to publish the law enunciated by its tribunals than to promulgate its legislation. On this subject, a circular was also issued to various local governments and the High Court. Later, he was replaced by, Sir Hobhouse as the law member. And he also became interested in the subject of law reporting and took initiative in the passing of the Law Reports Act in 1875 for the improvement of his law reports. At that time, Section 3, it gave authority only to the authorized reports by providing that no court would be, bound to hear cited or would receive to, or treat, as an authority, which is binding on it. So the report of any case decided by, any high court was, not everything was reported. So after the passing of this act, councils of law reporting, they were set up in several high courts, and reports, they began to be published under the supervision and authority of the government. But the Act of 1875, which was an attempt at creating a partial monopoly in the favor of the official reports, was strongly opposed. And Sir George Campbell, who was then the Lieutenant Governor of Bengal, he said that if you put into the hands of anyone authority, the power of deciding which of these decisions should be treated as authoritative or which are to be rejected or snuffed out, you give that authority, an enormous power over the superior courts of the country, and you will make him, in fact, the judge over the judges. So, the 1927, there was a non-official bill. It was introduced in the central legislature and containing provisions which, banned the citation of the non-official law reports. It met with a strong criticism and opposition, and it was ultimately collapsed. So, friends, before independence, the Privy Council in the United Kingdom acted as the highest court of appeal in India, and Supreme Court of India was established on January 28, 1950. The Law Commission, it was appointed in 1955. It dealt, in detail the question of the law reporting in India, and it has made certain valuable suggestions for improvement. So this was about the historical background of the law reporting in India. Now let us talk about the Indian legal system or the judiciary system. After the independence, India adopted the parliamentary form of democracy, and judiciary is primarily responsible for maintenance of law and order in the country, as all of us know. So judiciary, comprising judges at various levels, they provide checks and balances on legislature, on executive, and the court is vested with powers to resolve the disputes. They enforce the law by giving directions to central and the state government and all other authorities. So the Indian legal system has ensured constitutional rights to every citizen and is responsible for the survival of the world's largest democracy, that's India. Many important laws enacted during the British period, they continue to be enforced, still in the, Indian judiciary or the legal system. Indian Constitution, it came into force on 26th of January 1950, and Indian Constitution is one of the largest, written constitution, as you know, and it also guides the executive, the legislature, and the judiciary. So, if you talk about the provisions, in the Constitution, they are called as articles. And in all other laws, provisions, they are called as sections. So Constitution is a source of various laws enacted in the country. The executive power of the Union of India, it vests with the Prime Minister and Council of Ministers, and the President must act under their aid and advice. Similarly, at the state level, the state executive powers, they vest with the Chief Minister and the Council of Ministers, and the governor must act under their aid and advice. So if you talk about the law ministry, the Union Law Ministry, knowing about the law ministry and covering the Ministry of Law, Justice, Law and Justice in the Union government, it's very, very important beat. Various laws enacted by the Parliament, they are notified in the Gazette by the Law Ministry. And this ministry, it plays a very crucial role in appointment of the judges also. So it collects data on institution, disposal, pendency of cases in each court. And the law ministry, it implements various schemes for development and modernization of infrastructure for judiciary. Even the Bar Council of India and the state bar councils, they are also the regulatory bodies for lawyers. They also come under the law ministry. Now, let us talk about the most important part, that is the hierarchy of the courts. It is very important to understand, the hierarchy of the courts for a legal reporter, and to know the basic difference between each court. So there are different layers, in the judiciary hierarchy. The apex court, that is the Supreme Court of India at New Delhi. High court in each state and the union territories are there, and then there are the lower courts. There are magistrate courts, session court, district courts. The Central Bureau of Investigation, Enforcement Directorate, National Investigation Agency, NIA, which are under the control of the union government. They take up cases which have national as well as international ramifications. State police has jurisdiction to investigate the crime committed within that particular state. So the Supreme Court is the highest court of appeal in the country. And if you talk about Supreme Court, it started functioning on 28th of January 1950, immediately after the Constitution came up. So it was established under the provision of Part 5, Chapter 4 of the Constitution of India. And the said provision, it ratified the concept of the Supreme Court as the federal court, acting as the guardian of the Constitution of India. Also, it is the highest court of appeal. There are articles like 127 and 124 and 147 of the Indian Constitution that determines the jurisdiction and composition of the Supreme Court. So the present strength, if you talk about the present strength of judges in the Supreme Court, this is around
34,
including the Chief Justice of India. And the top 5 judges in seniority, including the Chief Justice of India, recommends names for the appointment of, Chief Justices, judges to various high courts, judges to Supreme Court, etc. And Attorney General for India is the top law officer in the Supreme Court. He, defends the union government, and he is assisted by the Solicitor General of India. The Supreme Court exercises original jurisdiction to deal with disputes among different states, or one state versus another state, or it also has an advisory role. So union government through president can seek clarification or advice on any matter under Article 143 of the Constitution. So this apex court, that is the Supreme Court, it interprets various laws, Constitution, and has the power to create new laws as well. My friends, Supreme Court is the one that can strike down the government policies, or it can restrain government from proceeding with a decision. So wherever there is a vacuum in law, judgments of the Supreme Court act as binding precedents. That's the power of the Supreme Court. Supreme Court also accepts to hear the appellate matters against orders passed by the high courts under its power of appellate jurisdiction. So it can enforce citizens' fundamental rights under Article 32, which is very important of the Constitution. It's important for you and me, our fundamental rights. So it hears writ petition when there is a suspension of the fundamental rights or a violation of human rights. This writ petition do not require to follow any hierarchy. It can directly reach the Supreme Court, and the article confers rights to ensure remedies through the Constitution. This, my dear friends, is the power of Supreme Court. Now let us talk about the next level in the hierarchy, that's the High Court. So high courts are the second highest courts in the judicial hierarchy, and they are the apex bodies in each state or union territory for that matter. As I said, Calcutta High Court is one of the oldest one, and they are governed by the bindings conferred by the Supreme Court of India so far as judgments and orders are concerned. So Article 214 Part 4 Chapter 5 of the Constitution of India specifies the powers of the High Court of India. It is the court of record, and it consists of chief justices and judges who are appointed by the president on the recommendation of a collegium of judges headed by the Chief Justice of India. The Chief Justice of Supreme Court, he is or she is designated as the Chief Justice of India. So the strength of judges, they depend on the population and the size of each state. And the Chief Justice of High Court is, the administrative as well as the judicial head in the state, and he or she has the control over all the subordinate judiciary. I mean, the High Court has control over the subordinate judiciary, the lower courts. And Advocate General is the top law officer in the High Court, and he defends the state governments, and public prosecutor, he handles the criminal cases. High Court, it governs the jurisdiction of the lower courts, as I said, whether it's the district court or family court or civil court or criminal court, and the other courts of the district, including bail or anticipatory bail. So the high courts have jurisdiction of hearing the appeals from the district, the civil or the criminal domain, if the lower courts appeal to the higher court. The High Court has original jurisdiction to hear the company law cases also directly. And there's an article called 226 of the Constitution which empowers High Court to protect the fundamental rights of the citizen. Similarly, I just told you about the fundamental rights to be protected by the Supreme Court also. So High Court also has the power to issue the writs of habeas corpus. What is habeas corpus? To produce the missing person in the court. So Q warranto, that is, the questioning under what authority a person is holding the public office, or giving a mandamus, that is the direction. I will be explaining the legal terms in the next video so that you are well versed with the technical jargons of the legal reporting as well. So the High Court can restrain the state from interfering with the rights of citizens, invalidate any law passed by the legislature or parliament. And through an interim order, High Court can stay implementation of executive decision. So this is the power of the High Court. Friends, now let us discuss about the lower courts, the district courts, under the discretion of the state government of the union territories, or the district courts. So these courts are structured mainly under several factors like the number of cases or the distribution of population, as I said. So depending upon those factors, the state government, it takes the decision of numbers of district courts to be operational for a single district, or clubbing together of different or adjacent districts. So the jurisdiction of the district court is limited to the territorial extent of the district, and the district judges are appointed by the state government. So the subordinate courts covering the civil cases in this aspect are considered as junior civil judges, or principal junior, or senior civil judge courts, or which are also known as sub courts or subordinate courts. So these subordinate courts, they cover criminal cases which are first class judicial magistrate courts or second class judicial magistrate courts or chief judicial magistrate courts, along with the family courts for dealing the matrimonial issues. This was about the district courts. Friends, many of you stay in a village also. You must know about the Panchayat, the village court. It's an extrajudicial body where the matters are solved through mediation. All of us know what a Panchayat is, but it's important to discuss here because there are matters which are decided by the Panchayat, and a legal reporter can also cover that. So Panchayat cannot force any of the parties to obey its orders. Neither can, the Panchayat pass a punishment. So India has experienced and still experience evil activities like Khap Panchayat, imposing their decisions in personal matters like matrimonial matters. That is not a judicial proceeding at all. Rather, persons who are involved in these kind of activities, they can be punished. But it's important to know about this. And then, you have out-of-court settlement as well by the Lok Adalat, which is an extrajudicial body where the parties wishing to, release each other from the existing judicial proceedings and solve the matters through mediation, it can take it to the, Lok Adalat. It is presided by a retired, district judge or government officials or, eminent personalities. Those who have an influence in that area, for example, a school principal or anybody, any eminent personality whom people regard and respect and listen to. And the decision passed by Lok Adalats, they require to be validated by the district courts. So this is, my dear, the structure of the Indian judicial system. But I would also like to add here the contempt of court, the understanding of contempt of court. So you, being a legal reporter, should understand what is contempt of court. So the law, relating to the contempt of court can be braced from the Contempt of Court Act 1971 and from various, case laws. I can have a separate video on contempt of court, but just to give a brief understanding of what it is, it can, be a civil or a, criminal offense. A contempt can be civil or a criminal offense. Civil contempt means willful disobedience to any judgment, to any decree, to any direction, to any order, or other processes of a court, or willful breach of an understanding given by a person to a court. There will be no civil contempt where there is ignorance of the order of the court, leading us to unintentional breach. Only the High Court or the Supreme Court has the power to initiate contempt of court action, and he or she may be punished for willful disobedience, which may extend up to, say, 6 months or an imprisonment. So if you do not obey any orders, it is considered as the contempt of court. Or for a legal reporter, it is very, very important to understand this. High Court of Delhi, for example, directs authorities that not to evict street hawkers, say in Sarojini Nagar in Delhi or in Rajouri Garden. So without providing them an alternative sites. But if the eviction takes place after the passing of the order, so the authorities are liable for contempt of court. You as a reporter, you write something against, against the case or the judge or the proceedings, something which the court thinks that it is not appropriate, is also contempt of court. And if you talk about the criminal contempt, which means the publication, maybe spoken or written words, or by signs or by visible representation of any matter, of doing of any other act whatsoever which scandalizes or tends to scandalize or lowers or tends to lower the authority of any court, then it is contempt of court. If it is prejudiced, or it interferes or tends to interfere with the due course of any judicial proceedings, then it is criminal contempt of court. If you interfere, or tend to interfere, or obstruct or tend to obstruct the administration of the justice in any matter, then it is criminal contempt. But there are defenses also. So the Contempt of Court Act, it allows 3 defenses to charges of contempt. It allows an exemption for those who innocently publish or commit acts that would otherwise amount to contempt. So if they reasonably believed that there was no ongoing judicial proceedings regarding these acts, and if they published something, or if they reasonably believe that the content of their words or actions did not contain anything contemptuous, then also it is a defense. The Act also specifically exempts fair and accurate reporting on the judicial proceedings and the fair criticism of the judiciary. You can do a fair criticism, my dear friends. In 2006, the Contempt of Court Act 1971, it was amended, and it allowed truth as a defense to contempt, provided that the person claiming this defense was acting in public interest. Then it is called as a defense to contempt of court. Now, my dear friends, I will soon meet you again with my next video on my channel Survidaya 77 with part 2 of the legal and court reporting, where we will discuss the important terminology of legal reporting as well as tips to how to become a good legal reporter. If you like my video, please subscribe to my channel for more informative videos on specialized reporting. Thank you.